G'day, Stephen Page from Page, Provan, Family and Fertility Lawyers, and now I want to talk about something I'm really proud of. It hasn't happened quite yet, but it's going to happen soon, and it should happen, but it will happen before the next state election. And that is, it's been 11 years in the making, and certainly 8 years since I've been pushing it. And that is that under the Anti-Discrimination Act, in Queensland, there is a clause that says that those who provide assisted reproductive services can discriminate on the basis of sexuality or relationship status. Really obnoxious stuff. But it was put there because many years ago a lesbian sought treatment from a Queensland clinic, and ultimately she was refused treatment, took the matter to the then Queensland Anti-Discrimination Tribunal, was successful, then that was appealed and was unsuccessful before a Supreme Court judge, and then unsuccessful before the full Court of Queensland. So this change was brought in to allow IVF clinics to discriminate. And why I say that those 2 years, back in 2013, which is, according to my maths, 11 years ago, the Gillard government changed the Commonwealth Sex Discrimination Act, in effect saying that you cannot discriminate on the basis of sexuality in the provision of services. But there was a get out of jail free card, because the states had provisions like this one, Section 45A of the Anti-Discrimination Act, and regulations were passed to give them time to get their affairs in order. Those regulations allowed the exemption until 1 August 2016, and for some reason Western Australia was an outlier in 1 August 2017. So in 2016, when it ended, I wrote to the Queensland Attorney General, Yvette D'Arth, after the Palaszczuk government had been elected. They'd been in power about a year at that point, and said, please get rid of this. This is really obnoxious. And a year later, I wrote to the then WA Health Minister, now the Premier, saying the same about Western Australia. Well, Western Australia has not yet succeeded in getting rid of its discriminatory provisions. But even though I'd written 8 years ago, nothing happened. And I certainly don't claim to have huge political power. I was just one voice seeking change. Then a couple of years ago, the Queensland Human Rights Commission did a report, Building Better, which was to look at its Anti-Discrimination Act and bring it up to speed. And I made a submission, again, about this provision, get rid of this provision. Tucked right at the back of the report, the Commission said, yes, we need to get rid of this provision because it's discriminatory, it's not consistent with what Queensland IVF clinics are doing, and it's doubtful constitutionally. The government endorsed that. A draft draft anti-discrimination bill, I should say, has since come about, and there's no reference to this section, but still nothing has changed. So when we came to the assisted reproductive technology bill process, the consultation process that the Queensland government started, and said we're going to start and finish this real quick before the next election due in October, I said, can you please get rid of this section? So tucked right at the back of the Assisted Reproductive Technology Bill, which has been introduced into the Queensland Parliament, is the repeal of this section. So when that bill is enacted, which I anticipate will occur before the next election, most likely by August 2024, that provision will go. It's only taken me 8 years to get rid of it, but the good news is that it puts beyond doubt with Queensland IVF clinics that they cannot discriminate in the provision of services based on sexuality or relationship status. It was a good day to see that last week. Thank you.